Good morning. Happy Tuesday. I've got a case management conference in about 20 minutes, so I'll have to keep this one relatively short. There has been some interest in the Frauditors exposed versus skip tracer lawsuit, so I'll weigh in on it ever so slightly. Frauditors exposed is Mark Stout, aka Stout pro se litigator. He went to prison. In prison, he got a paralegal certificate, and he passed a practice bar exam. Now, a practice bar exam is not a bar exam. I seriously doubt they gave him the equivalent of an actual bar exam. And I also seriously doubt that he was graded by the normal bar examination graders. So, I mean, congratulations to him, but he has never shown one modicum of knowledge about the law as far as I have seen. I don't follow him, but I've had some interactions with him, and he is a fucking idiot. Like, just to be honest with you, most people who go to prison are a standard deviation or more below the average IQ. IQ populations in prison are very low IQ. And, smart people don't tend to go to prison. Smart people don't tend to commit as many crimes. And when they do commit crimes, they're less likely to get caught. So it's kind of a sorting mechanism. If you've made it into prison, you're probably not smart. Probably not. I mean, there are exceptions to every rule, but the general rule is if you've gone to prison, you're not smart. And you're probably not smart enough to be competent, to be knowledgeable of the fact that you're not smart. So, Stout has a lot of strikes against him, unfortunately for him. I don't know anything about Neal, the skip tracer. I've watched 5 minutes of one video where he was doing the very thing that I always advise litigants to not do, is to go over your case. I mean, just don't do it. So that's a strike against Neal. He's not smart enough to have, I know he's watched some of my videos, he's commented on them. And what do I always tell litigants while they have ongoing litigation? Shut the fuck up. Don't talk about it. Everything you say can and will be used against you. And it's just not a smart thing to do. This is just driving me nuts. I'm going to just do that. There we go. So, and I don't mean any of this to help either litigant. Two things have been raised. The first thing is the quality of the complaint. It is, and this is a legal term, dog shit. The complaint is dog shit. There's so many avenues of attack. I'm going to cover a few that I think are more likely to happen than not. The first thing is he's in on diversity jurisdiction. These are state law causes of action. They're all defamation. Libel per se, I believe, is what he's going under. And as state causes of action, in order to get in under diversity jurisdiction, Stout's in Virginia, Neal is apparently in Massachusetts. In order to get in under that, the court has to believe that you actually have a $75,000 plus claim, unless it's gone up recently and I haven't kept track of it. Anyway, there is a high likelihood that the court is going to say, I don't think that your case is worth $75,000. I don't think you qualify for diversity jurisdiction. So that is something the court might do, just sua sponte, which means that Stout would have to bring it in Massachusetts state court, which isn't nearly as convenient or as much fun for a pro se litigant out of state to try to deal with. So that's the first big issue. The other issues are essentially things that the defendant would have to raise. And first, let's talk about choice of law, because that is going to be a driving issue on what law applies. Does Massachusetts state law apply because it's a state law cause of action? Or does Virginia state law apply? Now, under Massachusetts choice of law provisions, as far as I understand them, it's where the harm occurred in a defamation case. And because Stout lives in Virginia, the harm probably happened in Virginia. And so Virginia law will most likely apply. I'm not going to guarantee anything. We're dealing with pro se litigants, so who knows what's going to happen. So if we're applying Virginia law, the first real issue that I see is statute of limitations. Virginia has a 1-year statute of limitations, as far as I understand it, on defamation causes of action. And the alleged defamatory statements were from 2024. Now, the lawsuit was filed in 2026. If you do simple math, you can see that you missed a 1-year statute of limitations. Now, there are some caveats and asterisks around that, but I'm gonna go out on a limb and say that he's very vulnerable to an attack for statute of limitations. The other real big issue is I'm not entirely sure any of the statements are actually defamatory. The first statement that Stout alleges is defamatory, he takes a relevant portion out of it and he substitutes his own language, a frauditor, and then has a long convoluted story about how that is actually defamatory. Now, using brackets to put in substitute words is normally fine, like when you're doing a citation to a case. If the case is referring to Smith versus Jones, and the court says, Smith has to prove X, you can, if you're citing the case, you can take out Smith and put in plaintiff. So it says plaintiff has to prove X. You're not changing anything. You're just switching the name that the Court of Appeals was using with the title of that person in the lawsuit. And so you're not changing anything. But if you're doing defamation, you have to give the actual quote. You can't pull out what he actually said and substitute your own language and then say that that is defamatory because of all this convoluted backstory. I think that's ripe for a 12b6. And a lot of the other things are also very questionable, because if my understanding of Virginia defamation law is correct, you have to read things in context using the normal understanding, what a normal person would take this to mean. So, for example, when Neal said allegedly in the comments, I haven't looked up the comments to know, so I'm just going to assume that these are statements that are correct, that Stout was convicted for, I think, narcotics possession and a firearm possession, illegal firearm, something along those lines. I haven't looked it up in a long time. And Stout says, oh, well, he by omission, he failed to say that it was overturned on appeal. Well, first of all, were you convicted? Yes. Is it a true statement? Yes. Is truth an absolute defense? Yes. The fact that it was later, that a portion of it was later overturned on appeal, he still has a conviction in there, I think, for the firearm. But I think that, if I remember correctly, it's been a long ass time since I looked this up. At the appeal level, they found that even though he had signed a confession on his own sua sponte, this legal genius signed a confession letter. Not even at the request of the police, just on his own, just because he's a genius. Even though he did that, and even though he did a bunch of other things, the initial stop wasn't valid for the possession. So the possession part, I guess, was reversed and remanded, but the firearms part stuck. So, I mean, is there defamation? And if you have to have a long, convoluted backstory about all these things, is it defamation per se? I mean, it's really hard to do. It's possible for the inferences to be defamation per se. But again, the damages are so hard. I mean, Stout, from my understanding, lives in his parents' garage. He's a convicted felon. He prances around on YouTube pretending to be a legal genius. He was an auditor. But now he's no longer an auditor, but he did auditing right, and all the frauditors do auditing wrong, blah, blah, blah. I mean, it's just such a convoluted shit show. Last thing I want to touch on is in the complaint, I found this to be hilarious. Frauditors Exposed, Stout calls Neal, a.k.a. catfucker. And he goes into this thing about how this other person on this other site said that Neal download CP and other terrible things, right? And he says, I'm not saying it, but this other person said it. Well, what he did is he republished. He republished defamatory statements because, as far as I'm aware, Neal has never been convicted for CP. I'm not aware of any convictions of Neal. He may have some, I don't know. But unless he's been convicted of CP, that statement, by republishing it, is defamatory. And it's within the 1 year of Virginia law, or if on the, because it could happen, on a counterclaim, if one is filed, Massachusetts law might apply from the choice of law, because it's a different complaint. It's a different claim. Maybe. I don't know. I mean, this is going to be something that the litigants are going to have to duke it out over. And, two retards locked in a closet with knives trying to fight it out. I mean, it's always going to be an experience. But Massachusetts has a 3-year statute. So either way, if Virginia law applies, it's within the 1 year. If Massachusetts law applies, it's within the 3 years. I don't think the litigation exception, the absolute immunity for litigation, for claims made in litigation, defamatory statements made in litigation under Virginia law, would protect Stout, because that whole, I mean, it's completely irrelevant to Neal said X was defamatory, here's why. Any allegations of Neal being involved with CP, entirely irrelevant. And so if my understanding of Virginia law is accurate, which it may or may not be, I'm not licensed to practice in Virginia or Massachusetts, just FYI. So take this all with a huge grain of salt. But Stout might have some exposure for defamation. Now, I don't think either one of these guys has a pot to piss in or a window to throw it out of. I could be wrong. I don't think either one of them is making a bunch of money on YouTube. I don't think it'd be worth getting a judgment against either for defamation. Damages are kind of speculative, even if special damages, like actual, like I spent X amount of money going to a therapist, even if you don't have to prove those under per se, there's still a question about the general damages. You don't just get to state your general damages are X and get that. I mean, you still have to prove your general damages. And I'm not sure that either one of these guys has a sterling reputation going into it, where something like that would really affect their ability to make money, monetize, etc. So it's a clusterfuck, as these things normally are. Once again, just to be clear, I strongly recommend that both litigants shut the fuck up and don't talk about their litigation. Duke it out in private. Don't make it harder for yourself to win. And I'm saying that to both parties. I do not have a dog in this fight. I definitely don't like Stout, just because he's a retard spreading legal misinformation on the internet and involving himself through amicus briefs and lawsuits that have nothing to do with him. Unsuccessfully. And I don't know anything about Neal, but I don't know that he has a great reputation. So, I mean, usually bad reputations are earned. So I'm just going to go with, I probably wouldn't like him if I met him. So, there you go. But maybe I would. Who knows? I mean, I've watched 5 minutes of his video. He didn't impress me because he was talking about his case, but maybe he's a sterling gentleman, and maybe I'm being too quick to run to judgment, although normally gut instincts are correct. Anyway, that's all I got for you today. I got to get on to my call. Thanks for watching. Have a great day.